Delegate Greason, Delegate James, Delegate Robinson, Delegate Head.
Here.
Delegate Carr,
Here.
and Senator Wagner.
Here. Good.
Yes, sir.
Okay, we have a quorum. Good. Thank everybody for showing up today. This meeting was called as a result of the governor's recent executive order regarding the implementation of the Clean Power Plan and cap and trade on Virginia through regulatory action that he has established. For those that may not have been on a series of Commerce and Labor meetings that Delegate Chairman Kilgore and I hosted when the President Obama rolled out his thoughts on the Clean Power Plan, we heard from a number of different stakeholders during the presentation. The one that was probably the most compelling was that was provided from the State Corporation Commission that estimated on the initial rollout that the economic impact to Virginia and the ratepayers would be some $6 billion, would it be, dollars, that would be ultimately borne by the ratepayers of Virginia across the board, as various existing generating facilities would have been required to close down way prior to the end of their useful life, and replacements would have had to come online, and those capital costs of the replacements, as well as the stranded costs associated with the early retirement of existing generation facilities, would have caused this large dollar value. The assessment on what the cost to ratepayers would have been under a cap and trade program was still trying to be analyzed and go forward with it. I think various states had filed lawsuits. The question was very much in doubt in the courts at the federal level. And then obviously there was an election in November that changed the paradigm somewhat, that indicated that perhaps the Clean Power Plan would not move forward, or at least that the Solicitor General from the United States would not be there to actually defend on behalf of the previous administration those regulations, and seemed to mutter down to an area of not priority and not much talk. Then recently here, within the last 2 weeks, the governor announced that despite what was going on at the federal level, that he was going to unilaterally ask for regulations to be put together by the Department of Environmental Quality, presented to the Air Board, that would allow the Clean Power Plan to be moved forward, along with a compact between other states to move forward with a cap and trade program. Which brings us to this meeting to go forward. As you know, our responsibilities are multifold. One is that to review all regulations to ensure that they comply with the intent of the General Assembly. If they don't, then we have the ability to suspend, with the concurrence of the governor, a regulation that's proposed until the next session of the General Assembly. I think at least 2 years ago, the General Assembly has acted on their intentions on this in a manner opposite to that the governor has put forward. So we are here for the meeting to review that, and we've asked Secretary Ward, is she here? Do not see her. I'm sorry?
Sir, I believe that they were told at the meeting and were not able to attend. The date, ahead of time when the dates were sent out, they were not able to attend.
All right, and Mr. Paler was unable.
Same way.
Isn't it? Okay. And do we have anyone from the administration that would be here to talk? Okay. All right, they were invited. It was thought that they would be here. Staff had told me that they would be here recently, and now I found out that they're not to be here. So are there comments from the commission on this? Is there anyone here from the AG's office? Is anyone here from the executive branch of the government?
Mr. Chairman.
Yes, Senator Edwards.
In terms of comments, one of the questions has to do with the timeliness of the hearing today with this Administrative Review Board. It's my understanding the only thing the governor has done is issue an order to the agencies to get the process started. There are no regulations at present, and my understanding is that our commission is to review proposed regulations. Since there are no regulations, I'm not sure that it's appropriate that we even have a hearing. So I'd like to have some kind of discussion on that first, as to whether or not we're not premature and whether or not it's even ripe, that's a legal term, by the way, ripe for hearing regulations which we don't have before us.
Delegate
They're not going to be
Lingenfelter.
prepared, as I understand it, until about a year from now.
Okay, Delegate Lingenfelter.
Mr. Chairman, my curiosity is, I mean, as long as we're here, to delve into some questions with respect to the process to a certain extent. My understanding is, as Senator Edwards just mentioned, the governor has issued orders. And please, someone correct me if I'm wrong about this, staff, maybe you can help me out with this, but the orders to the DEQ to look at potential regulations, and then I guess the Air Control Board would be responsible for actually producing that regulation. And so my question is, I think it's clear the governor can issue executive order. That's not an issue. He's probably within his legal authority to do that. The question is, what authority does the Air Control Board have with respect to producing the regulation and specifically entering agreements potentially with other states? The reason I ask that question is, Mr. Chairman, my thinking is we probably have a lot of work in front of us, and it would be good for the committee to understand how we need to intersect with this process, because it appears that we are headed there based on this order. Because I think the government is serious about it, and I think we ought to make sure that we at least understand, people in this room understand, what role your joint commission is going to play with respect to sorting this out. So I think it would be good to spend a little time with the process. I would defer to Chairman Ware on that too. I mean, we get into this business a lot. It's good to understand what our expectations are going forward.
Delegate Ware.
Mr. Chairman, I was somewhat surprised to see the governor's unilateral action with this executive order. And I'm concerned, first of all, as you might guess with a civics teacher, about the propriety of an action of this sweeping magnitude originating in the executive branch. Had a chance to look back, as I do from time to time, at the state constitution, Article 4, Section 1 says this, simply, the legislative power of the Commonwealth shall be vested in a General Assembly, which shall consist of a Senate and a House of Delegates. The breadth of the executive order that is suggested here and its sweeping potential, as the chairman has indicated, to affect the costs of the average Virginian for their rate paying is surely something that ought to be considered and have a full debate, in my judgment, in the General Assembly before it were to take effect. I am deeply concerned that this is underway without any legislative or statutory provision upon which it is based. In fact, as the Assembly has acted, I would say perhaps the most pertinent, specific connection would be House Bill 2 from the 2016 session, again alluded to by the chairman. Delegate O'Quinn had a version, Senator Chafin had a companion version, Senate Bill 21. Those passed both chambers. They're on point in many particulars related to the governor's executive order, and it was necessary for him at that point to veto the legislation. I don't have a problem with the governor having a different point of view on policy. That's exactly as it should be. But what I do have a problem with is him reaching beyond, or his administration reaching beyond the statutory and even constitutional authority, which is vested in this. This to me is troubling.
Mr. Chairman.
Senator, Delegate Lingenfelter and then Senator Edwards.
I think, Mr. Chairman, I think that Delegate Ware is on point, and it brings to mind a question that we're contemplating, which is essentially, has the administration, for instance, the reason I asked about the AG to you in the sidebar, has the administration asked the Attorney General whether the General Assembly approval would be required? Again, I'm thinking downstream here, after a regulation is promulgated, after it goes through the 60 days of public comment, after it goes through an appropriate period of time for shaping by the administration to ensure that the public's comments are included and it hangs together and is legally sufficient and so on and so forth. Beyond that, would the AG opine whether or not the Attorney General, or rather the General Assembly, would be required to approve a regulation of, say, a multi-state approach? Because it seems to me in reading the governor's executive order, he has indicated a corresponding relationship. Well, corresponding with who? I mean, I'm sure it's not corresponding necessarily within the state. I think it clearly involved Virginia, but corresponding with who? In other words, are other states involved in a potential agreement of this nature? And let's assume for the sake of discussion that that was efficacious and that we would want to be involved with another state. Can that be done without the General Assembly weighing in, according to the Constitution, as Delegate Ware has pointed us to? I asked the question.
Mr. Chairman.
Unfortunately, and unfortunately, Delegate Lingenfelter, there's no one here from the administration or the Attorney General's office to answer that question. Senator Eccles.
Yeah, Mr. Chairman, I think I can answer. We do have in front of us in blue an Attorney General's opinion, May the 12th, 2017, which is fairly timely. I think where the Attorney General opines that the Air Pollution Control Board does have authority in this area. In fact, the Attorney General very specifically says the Air Pollution Control Board specifically has the authority to establish a statewide cap on greenhouse gas emissions for all new and existing fossil fuel electric generating plants as a means of abating and controlling such emissions. You have the opinion in front of you. It seems to be a solid opinion, and it's my understanding what the governor has done is simply asked the Secretary of Natural Resources and the Air Pollution Control Board to begin the process of adopting regulations. And that process includes, in particular, bringing the public in for comments. We don't pass regulations unless the public is involved in the process. The public submits comments, and then they go through a fairly elaborate process of adopting regulations. And at the end of that, if somebody says it's outside the authority of the Air Pollution Control Board, then that can be appealed to the court system. So there's due process, there's public comment, there's public involvement. Nothing's going to happen overnight. We know in Virginia the process of adopting regulations is sometimes long and laborious and takes a number of years in some cases. So I think that's all the governor's done is get the process started. If somebody thinks that it's outside the scope of the Air Pollution Control Board, that's an issue that can be raised in the process or on appeal to the courts. And if the General Assembly wants to get involved in some process, the General Assembly can do that. Every year we meet, pass bills, both houses, and the governor has to sign them. And we'll have a new governor presumably in January. Our governors cannot succeed themselves, as we know. And so there's a due process, there's public involvement. I think it's always appropriate for the governor to get this started. And the question is, what is our role now? And I think my position is our role is, we don't have a role at this point until some regulations are proposed. Right now, we have no regulations proposed.
Senator Edwards, I would point out that we do have a role. If you read his executive order, it calls for a multi-state compact. The Virginia Air Board jurisdiction stops the borders of the Commonwealth of Virginia. They have no edict to move outside the borders of Virginia. He's proposing that regulations be drafted now that would include a multi-state compact where the Air Board has no function outside the borders of the Commonwealth of Virginia, which is exactly why we're here today in this meeting to point it out. Unfortunately, we have no one from the executive branch or the Attorney General's office, and I will point out that there's been ongoing litigation in New York and New Jersey regarding these exact same issues of trying to reach beyond the borders of the state and bring other folks into it. So I would point out that that's exactly why. we're here.
Well, Mr.
Senator
Chairman,
Edwards.
I don't object to being here at all, and I think this is a good issue we need to talk about. But as far as what are we going to look at, until there's some regulations, whether it be multi-state or just simply, as you correctly point out, the Air Pollution Control Board stops at the border. Until there's something to look at, I'm not sure what we're doing other than just voicing our views on the subject in a more general fashion.
Senator Edwards, I will say this, that there were already regulations being drafted as a part of complying with the existing Clean Power Plan until it got evaded in court. The Department of Environmental Quality was formulating regulations. So I would say to you, there are regulations in the draft form being worked on and have been worked on for the past 2 years as a result of the initial Clean Power Plan from the federal government. Although it was in doubt whether or not the courts would approve it, that did not stop the regulatory actions from the preparation of those regulations. So I would submit to you that they're a lot further along than people might consider
Well, Mr. Chairman,
right now. And I will also point out that I believe the governor's edict is to have those regulations presented to the Air Board in December. And I would point that out also, that I believe that was part of the executive order.
Mr. Chairman, we don't have them in front of us now, though.
Yeah, hang on a minute. I believe Senator DeStefano had comments. Go ahead.
Mr. Chairman, that to your point on that, that's probably my biggest concern is the fast track nature that this has taken. It has been my experience and observation both before I was elected and certainly afterwards that even in the face of clear legislative direction, regulatory changes and certainly development of them have been a very, very slow and laborious process. And that's not necessarily a bad thing. While I'm all in favor for much more efficiency, when you've got an executive order in the face of something that should have had basically everything on a complete dead stop to accelerate things faster than I have ever seen anything done. I mean, we want you to be done and ready to roll this out to public comment in 6.5 months. That's a pretty fast train for any part of any level of bureaucracy in this town that I have ever seen operate. And while I certainly think that efficiency is to be in order, that you end up with a train wreck if you're not real careful. And you know, we don't have any legislative directive here. It just really concerns me very, very much what this governor has done with this.
Mr. Chairman,
Senator Edwards.
again, the point is, if we have nothing in front of us, if it's to be ready for public comment in 6 months or 1 year, whatever, then that's the time maybe to look at it and see what it is and weigh in on it. But right now, we don't have any regulations at all in front of us.
Appreciate your comment. Senator DeStefano.
Mr. Chairman, if I may, we have a report and final recommendation to the governor dated May 12, 2017, which talk about implementing RGGI, Regional Greenhouse Gas Initiative. So since we don't have anything in front of us, maybe you have a different package than I have, but mine has it in here. And when we look at the discussions on this, we're looking at something that has a $6 billion impact, raising the taxes and the energy bills on our elderly, on our military, and others on fixed income. I've seen regulations on average take between 18 and 36 months. This one trying to jam it through in 6 months, I believe is irresponsible. And further, it's the governor trying to take a unilateral approach to the legislative process and usurp that process or short-circuit that by implementing a regional market-based mechanism that we're all familiar with. It's called RGGI. We get briefed on this, and we've been briefed on this for the last 4 or 5 years. If we thought this was a good idea 4 or 5 years ago, then we would have started to look at and study it at that point. But for the governor to take unilateral direction on this, provide it and move it forward, and then try to jam it through in 6 months, when we all know that regulations take 18 to 36 months to get through the system, and providing a tremendous impact on our elderly, military, and others on fixed income is in direct contradiction with Article 4 of the Constitution, which says that the House and Senate are the ones who make our laws and drive the train, as Chairman Ware stated earlier. Mr. Chairman, I think this is complete government overreach. This is the governor trying to take and make unilateral decisions and basically usurp the authority of the House and Senate or the General Assembly, which goes against our Constitution, Article 4. Thank you.
Mr. Chairman.
Senator Edwards.
Again, maybe for the last time, we're putting the cart before the horse. The governor's order said that the proposed regulation should be available for public comment, period, by the end of the year. Public comments when the process of the public is brought in. And maybe we could have a meeting after the first of the year, take a look at the proposed regulation. But right now, we have nothing in front of us to talk about. And it's not government overreach. This is the beginning of the process. The regulation won't go into effect for who knows how long. It'll be a few years.
Mr. Chairman.
Delegate Ware was next, and then the Senator Delaware.
I find it a curious construction to say that we put the cart before the horse. I would also say, just from a procedural standpoint, I've been on this commission for a number of years. This is the first time we've had no one of any office at all representing the executive branch before us. I find that likewise a troubling thing. But I also find it troubling to think, in light of what we've said, that we would preemptively cede the legislative authority of the General Assembly, and as this would have the effect of doing. I for one, will not follow that trail.
Senator McDougal.
Mr. Chairman, I remind Senator from Roanoke City and the rest of the committee members that we convened a meeting that was actually held a little bit up the way not too long ago, where regulations were presented, and we saw that they were approved before the public comment had even been completed by the executive branch. During that time, we also saw that the vast majority of comments made on a particular issue were not even included in the final report that was presented. So even though he might not have concerns about how these processes go, I certainly have seen a track record of creating what the end result will be, presenting that end result going forward, then having that end result be presented to the public before the comment period is even over, and then saying, well, we're just going to go ahead and do it. So I, for one, do not feel that this is putting the cart before the horse. I do think that this is definitely a topic that we should be discussing. It should be a legislative topic that we're dealing with. It should not be what an executive branch does in the last 6 months of their administration with no input from the legislature. And the senator can see from the report that was given that even apparent this working group had no member of the legislature was even invited to consult or present during that time. So there has to be a point where the legislative branch has input on things that are legislative in nature. This is rulemaking, it is legislative in nature. We have not had input, we've not had the ability to express views for or against. It is not the way business should be done in Virginia.
Delegate Lingenfelter.
Mr. Chairman, just a couple of points to clean up some things that have been said. I agree with Senator Edwards that it's important for us to be here. And I think that it is important for us good to be here, as he said, because we're having a chance as a joint commission of the General Assembly to sort of share, whether we're going to have to do that through the press now because they're here, to share at least with the administration that we've got some significant concerns, not only about the policy, but the process as well. This is a significant thing that the governor has directed be done. And it is important that the General Assembly be heard about this early in the process. So I commend you for bringing us together on it. I don't think that this is just for theatrics. This is important that we get the process right, and that we make clear that we need to intersect this process to ensure that the General Assembly's views and feelings about this are considered. A couple points. When Senator Edwards was speaking about the Attorney General's opinion, it's this little blue thing, and I think you could probably get some copies of this. It really doesn't go to the issue that I raised in the first place, which is what is the multi-state jurisdictional authority of the Air Control Board to regulate beyond the borders of Virginia. The Attorney General, his opinion, I think, is silent about that. That's a big issue. In my reading and understanding, having been in the General Assembly for a little bit, is that when we do multi-state pacts, that's our domain. That's our wheelhouse, as Delegate Massey likes to say about business. That's our wheelhouse. And it's important that the administration understand early on in this process that if they are developing regulations, they need to walk with us and consult us in the process. They don't have to, but if it, just as a good business practice, the administration ought to involve its co-equal in government in this very important endeavor. And there may be some efficacious value. That's a policy question that needs to be robustly debated. But it doesn't seem to me a very smart process not to address this fundamental concern. The other piece is this. We don't have a regulation in front of us, but we have an executive order, which is the most important act a governor can take aside from sign a bill into law or veto it, is to issue an order to an administration to do something within his authority. And let me just be very clear, of stringency to limits on carbon dioxide emissions imposed, here's the point, in other states with such limits. The governor's executive order is very clear, Mr. Chairman, that this is to be a multi-state pact. And so, if we just set the policy debate aside, and I agree that there are policy issues we have to consider. I think everybody here wants clean air. And I think everybody here wants jobs and opportunity and the revenues to do the kind of things we want to do in the state. I think that's not a debatable point. The question is, how do you get there? But here's my process question that I think is awfully important to ensure that we all understand going in, even though, Senator, we don't have a regulation yet. This executive order is very clear that this is to be a multi-state endeavor. What authority does the Air Control Board have to enter a multi-state agreement? Will their chairman, who I understand is authorized to request an Attorney General's opinion, ask that specific question? And if they won't, will the governor come back and ask that specific question of the Attorney General, whether a board, a duly constituted board of Virginia under the administration, can enter a multi-state pact without the approval of Mr. Jefferson's legislature? And I don't think that he can. That's my point.
Delegate Carr, I'll be right with you. Let me just make one comment. We all know this is probably the biggest proposed regulation that's ever been established in the 25 years I've had the honor and privilege to serve here. We have studied at length, because the Commerce and Labor Committees, the economic implications of the imposition of this regulation and what it means to everything from the coal industry in Southwest Virginia to electric ratepayers, regardless of where they are. We've heard from industry input from those that employ literally tens and hundreds of thousands of Virginians about what the impact of this would be to their company. We've heard from environmental groups about the impacts, the proposed impacts from that. We have been studying and looking at this issue for the better part of 2 years. It was interesting that the governor, just during the session, said, well, we don't really need a 5-year rate freeze while we go through this transition. There's no need for the bill that I carried 2 years ago. He said that just as recently as 3 months ago. And here we are sitting here today, 3 months later, with that imposition of exactly what he was saying we don't need to worry about. And his words, don't need to worry about, because it's not going to happen in Washington. Now all of a sudden, I guess we should worry because he is going to unilaterally try to put this on Virginia. And I would also say to the members here, and if you're new to this, this is probably the largest audience I've ever seen at a JCARS meeting ever. So clearly there are implications on both sides. And I understand there's people on both sides of this issue. And, but this is a significant. If you look at the agenda, which I thought was altogether appropriate, we had asked the secretary to come in here and give us an outline of a working plan of what she intended to do, and as she moved forward with this, so that the entire commission, and indeed the public as a whole, would have an understanding of what's going on. I can tell you this has been going on, and when the EQ first got it, and we were looking at that plan, they said it would take years to put together these regulations to move forward with in compliance. And in fact, there was discussions that EPA had to move the 2017 date even later because they understood just how complex it was for every state across the country to try to put these regulations together and get them approved. I would point that out. And so now all of a sudden, the governor of Virginia has proposed accelerating in a 6-month period that just about every state across the country said, we're going to need more time. And that was 2 years ago. We're going to need more time to try to put something in place that impacts Virginia, every Virginian across the board. Everybody who writes a check for an electric bill is going to be impacted by this. Everybody in Southwest Virginia who's looking at coal is going to be impacted by this. We asked the secretary to be here today for one reason, just to tell us what's your plan, because we're very concerned about it. And for good reasons, we're very concerned about it. We asked for a presentation on the carbon reduction rules from someone in the DEQ's office. We thought that was important, to get an idea of this commission, because it's our responsibility on behalf of the General Assembly to take a look at any proposed regulations. Something of this magnitude, I felt it altogether appropriate that we call this together, and obviously based on the attendance, and a whole lot of members felt it was appropriate to be here today also. And we asked for a presentation on the legal status of where the governor's coming from, to answer those questions we just had today. Does the Air Board have the authority to enter into a multi-state compact? Are those questions to be answered? Are they to be asked? Is anyone concerned? But obviously the administration is not even concerned about that, or the Attorney General's office is not even concerned about it, enough to send a representative to the General Assembly on that. So I would point that out. Delegate Carr, I believe you were next.
Thank you, Mr. Chairman. Just a point of clarification. I believe that the meeting was set in spite of the fact that Secretary Ward and Director Taylor had indicated they could not attend on this particular date.
Well, they have deputies, they have assistants, but you would think someone from the office could come. Senator DeStef.
Mr. Chairman, if I may, right before this meeting at 9 o'clock, I met with 3 members of DEQ on another issue. On the way in this morning at 8:30, I saw 6 members of the Attorney General's office, all friends, walk into the building. Earlier, when I was walking on the street, I saw multiple members of the executive branch and the administration walk into the Patrick Henry building. So I think for us to call this hearing, and the executive branch and the members of DEQ, Office of Natural Resources, the Attorney General's office, not to show up for a hearing such that we've called today to discuss these very important items is just disingenuous of the executive branch to admit, to just ignore these hearings today. That's all I have to say, sir.
Mr. Chairman.
Senator Duke.
Mr. Chairman, as you know, Section 30-19 of the code gives the chairman of a committee the authority to request a review by JLARC of the fiscal impact of any proposed regulation. I don't know if you have done that, but I would like to formally move that this committee request that you ask JLARC for that fiscal review of the impact of this proposed regulation on the Commonwealth.
I hear a motion, do I hear a second?
Mr. Chairman,
Discussion.
yeah, Mr. Chairman, again, I'm the cart before the horse guy out here. We don't have any regulations, so I don't know what exactly JLAR's supposed to look at. But so, I mean, obviously, if we have regulations, that's a good idea. Look at the fiscal impact. We in Virginia always have somebody, usually the Finance Committee, the Appropriations Committee staff, look at fiscal impact of anything we do, but I would have no objection to that if we had any regulations in front of us. So I think it'd be kind of useless to adopt that motion.
Other discussion? No, no, no.
Well, J-Lark, I think someone from J-Lark is actually here. Maybe not. But it does seem to me that at a minimum, we ought to put them on notice to get ready. I mean, that's again part of this whole process piece that needs to be integrated. This is not, this is not going to be some sort of simple regulation about how tall stoplights have to be. Okay? It's a big, big deal. And I think the sooner that we align the expertise to begin to track and follow this stuff, the better off we're going to be. So in that regard, I support what Senator McDougal is suggesting, is that J-Lark do get some advance warning on this and begin the process of at least tracking what the administration is doing with its proposed regulations. As soon as they propose something and it goes out for 60-day comment, that's a perfect time for J-Lark to begin straight away looking at the context. But in the meantime, I don't think it's unusual, or I don't think it's particularly insuperable that they would take the executive order and make some assumptions. I mean, take a look at what New York did. New York has done this. That's a good place to start. Do some research and see what happened in New York when they promulgated regulations that crossed their state border and went out. I think that's a good start point to go. Again, we need to recognize that this is a big body of work, and the sooner we get the several parts moving and engaged in looking at it in a serious way, the better off we're going to be, as opposed to, Mr. Chairman, as you've seen, where we all pile in after comment, we have a regulation, it gets presented to us, and sometimes it's first blush for us. Sometimes we haven't seen it at all. So I find it refreshing that the idea that we might actually engage the government to get busy and look at something in a serious manner from the get-go. Just my little sermon.
Mr. Chairman.
Let me just make a comment. I think J-Lark, and we went through this just when the initial Clean Power Plan rolled out from the federal government, proposed regulations. We were readily able to calculate what the economic impact would be, and then they revised the regulations in the second round, and they were readily able to figure out what that economic impact would be based on reduction in carbon output provided to Virginia from the initial proposed regulation. So I think Senator McDougal's on point. We need to begin to understand, if it takes this form, what are the costs? If it takes this form, what are the costs? And I think J-Lark can get us into the ballpark, so at least this commission and the rest of the General Assembly has a working knowledge of what the costs would be if this form of regulation takes various impacts and move forward.
Mr. Chairman,
Senator McDougal.
let me make sure I'm not 100% sure I articulated my thought as clearly as I should. Two separate things. I'm asking that J-Lark review the fiscal impact of the executive order on the state agencies, what it takes to implement that, staffing and cost-wise, because clearly that was not presented in the budget that was approved not too long ago. And then second would be the fiscal impact, and I think this is wider, not just on the agency, but on the Commonwealth, of a proposed regulation. And I'll remind the committee members and the public that typically when we put something in statute for directing an agency to promulgate a regulation, we have a fiscal impact that is traditionally produced by the Department of Planning and Budget, and only within the last couple of years have we been able to have a legislative review of those numbers. And we do not do, certainly the Finance Committee on the Senate side and the House Appropriations Committee on the House side look at it, but J-Lark is our joint body independent review of that. So I think that this is absolutely the appropriate time. If this had gone through a legislative process, J-Lark would have certainly been looking at that fiscal impact before the legislation to promulgate a regulation was approved by the members. So two separate things. J-Lark review the fiscal impact of the executive order and of the proposed regulation as we would do through any normal legislative process.
And that is a substitute motion?
Clarifying, yes.
Clarifying substitute motion. It's been properly seconded by Delegate Lingenfelter. Any more discussion?
Mr. Chairman,
Senator Edwards.
with regard, we have a budget that's already in place. Obviously, the governor can't spend any more than is already there in terms of the process of coming up with these proposed regulations. As far as the other issue having to do, I guess, the cost impact on the economy of the Commonwealth, that's a very good issue to talk about. First of all, we know, the governor said, and we know this from public sources like the New York Times recently wrote an article about this. Many of our larger corporations today have in place climate change or clean energy policies. In fact, half of the Fortune 500, almost half of the Fortune 500 companies today in this country have in place climate change or clean energy policies that they follow. And we know that many of our largest corporations, such as, for example, Google, Amazon, Microsoft, Walmart, Bank of America, and many others, say they're not going to go anywhere unless they have clean energy. In fact, recently I've read where the American Electric Power Company, the parent for Appalachian Power, which covers a lot of part of Western Virginia, had a summit meeting with some of their larger customers, in which they said, we need to have clean energy. This is Appalachian Power Company and American Electric Power. They use a lot of coal. Their largest customer says, we want you to go forward with clean energy and not the carbon-based energy. And the Appalachian or American Electric Power Company has indicated they're going to move in that direction. We know Dominion is moving in that direction. We know that from a business standpoint, we're going to create jobs if we move in a clean energy direction. In fact, solar energy job creation has been 65% in the last year alone, 65% in solar alone. And so we know this will be a job creation mechanism if we move forward with a more of a clean energy policy the governor wants to do. Secondly, Mr. Chairman, we know that 98% of the scientists in the country know that we need to move forward with clean energy. It's a climate change issue, a big, huge issue that almost all the scientists in the country and the world are moving in that direction. And we also know, Mr. Chairman, that the United States Navy, at the highest command, has said climate change is a serious, serious national security issue. We're already seeing this issue down in the Norfolk area whenever there are more vicious storms and there's more flooding. It goes on when we have storms. And we know the sea is rising. And the lower level parts of our country are seeing that. So we have to go forward in the future, not turn the clock back. And I think the governor's on the right track. The governor's on the right track in building, pushing forward a policy of clean energy for the future. That's the future of Virginia, and we should not, as a commission, try to turn the clock back.
Sure.
Delegate Lingenfelter and Delegate Ward.
Just briefly, just to Senator Edwards' point, to those who agree with him, there may be efficacious value, but the point that this commission needs to wrestle with is what is the process by which we get to the truth on the impact of this regulation. And I know that I got it on the things that Senator Edwards said, but there's this issue of what is lawful. What is lawful to do? And it seems to me that we need some clear answers about what is it that's lawful for the Air Control Board to do. Because I got to tell you, as a General Assembly, I think this is in our domain.
Delegate Ward.
Mr. Chairman, I move the pending question.
It's been moved and pending question. There's a second. Second. It's been moved and seconded. The pending question be ordered. All those in favor say aye. Aye. Any opposed?
No.
Got 2 noes, recorded noes. Okay, the pending question's been ordered. All those in favor of Senator McDougal's proposal and letter, say aye.
Aye.
Are there any opposed?
No.
2 noes, recorded noes. Okay, that motion's been prepared. I think we talked at length about this. My only response back to what Senator Edwards' most recent comment was is that I will point out that our utilities, investor-owned utilities, and co-ops that generate have reduced overall carbon output by 27% over the last decade, and they are on a glide path to continue that. And we have seen an integration of more solar throughout Virginia, and I don't think there's anybody up here that's done more for putting solar forward than Virginia than myself in terms of legislation and bills to move solar forward.
Congratulations.
Well, I'm not looking for condolences or congratulations. What I'm trying to do is point out that we are on a steady path. What we're talking about here is jerking that path and forcing a whole lot of money and a whole lot of expense and bills moving forward unnecessarily when we've got a good glide path to move towards cleaner energy production. We got a great glide path to integrate more solar into the overall production path. And unfortunately, the Secretary's not here because we had opportunities, I think, to really ramp it forward in terms of a power line that was moving across the James River, which the Secretary, $170 million power line, of which the Secretary negotiated an additional $85 million in mitigation money that they are going to use for various little projects within the Department of Conservation and Natural Resources. $85 million that in my mind could have been used to deploy more solar, and in my mind could have been used to provide energy research and development to our universities for energy storage, but was used in other places. I will also point out that my understanding is they've been so successful. Make no mistake about that $85 million. It's going to be borne by the ratepayers of Virginia as part of a rate adjustment clause. So basically, a $170 million power line is now going to go to $250 million, and it will be absorbed by the ratepayers of Virginia. Similar actions are ongoing right now and being considered on the Atlantic Coast Pipeline. More mitigation money provided unappropriated by this General Assembly into the executive branch of mitigation money that will ultimately be borne by the ratepayers as that pipeline is built. So make no mistake that this is going on also. Unfortunately, the Secretary was not here to answer those questions, but it brings up a number of questions of myself. And make no mistake, it's the ratepayers ultimately that will shake out. And when these rate adjustment clauses come through and the rates go up, it'll be the investor-owned utilities that are blamed and to move forward with it. But this is a no question power line had to be built. I sat down with an hour for the Corps of Engineers and he confirmed everything that was moved forward on it, and perhaps we won't get a power line built, who knows, in some time, but unfortunately she's not here to answer that. We've gone over this. I happen to think that we're on a great path to make that transition in Virginia. Some of the comments in the governor's own executive order indicate that we're on a pretty good path to do that. The question is, do we unsettle the apple cart? Do we move Virginia into a very uncompetitive posture at a time when we're trying to diversify Virginia's economy? And although I can appreciate what Senator Edwards said at the time that executive order came out, I was with a major manufacturer. Walked in the morning, the executive order had come out. I said, how's everything going today? And he said it was going real well till this morning. And it was exactly the thing. So if you don't think that has an impact on businesses across Virginia that are existing here today, think again. It has impact in virtually every boardroom of anybody who pays a nickel for electricity and is very, very concerned about the actions here in Virginia. And I think it may have a chilling effect on economic development, but that's my own personal opinion. So with that, I believe there's one more item on the agenda. Item 4, and perhaps Emily Steinhibler and Molly Mitchell decided to show up because no one from the administration or the Attorney General's office wanted to show up. So are they here today? Okay, we're 0 for 4. All right, there's one other administrative thing that needs to be clarified as part of this meeting. And Karen, I would ask you to fill in the actions of the legislation that was passed this session and bring us up to speed, if you would, please.
Certainly. Last session, House Bill 1731 passed, which charged this commission with looking at all of the exemptions from the Administrative Process Act. The purpose of the review was to assess whether there's a continued need for each of the exemptions. In the APA, there's basically 2 types of exemptions. The vast majority are agency-specific. One's granted to, for example, game and inland fisheries. There's nothing for the Housing Development Authority, etc. And for those for those specific exemptions, the agencies are required by the bill to provide information and an explanation as to the necessity for their particular exemption. There are a few general exemptions in the APA that can be used by any state agency. For example, the one that requires the regulation to change to conform to Virginia law, a change in the law where there's no agency discretion. They're just following suit to what the General Assembly has directed. So a question has arisen is whether there's any need for agencies to provide information on that general exemption. And based on my review, I really don't believe that they do, because the need for that exemption is going to be the same for each agency, and the reports would just be repetitive. It's needed because we have to conform to state law. We have to conform to state law. And so I can provide the information through the registrar's office just generally about the use of that general exemption, and then you all can determine which ones need to be modified. Now, proceeding this way, which is again what I would recommend, doesn't preclude or affect your ability, once you get some of that information, if you want to then get additional information from a specific state agency on their use of the general exemption. But I think doing it this way would be more efficient for everyone. It will save you all from having to review a lot of repetitive information. And so that was the plan for proceeding. I just wanted to let the commission know. The other thing you will need to do is set up a schedule for review, and that's completely at your discretion. So we would look at that. The trigger for the commission's review is November 1 of 2017. Agencies will begin reporting in August 1 of 2017. And so once I get that information from the agencies, I would have a better idea of what schedule to recommend to Senator Wagner for the commission to proceed. So if that's all right, that would be the plan.
Thank you. Thank you. Any questions for Karen? Okay, I've been informed prior to adjournment that we had one request for a public comment. So, and sir, I apologize, I do not know your name, but please come join us.
I appreciate it.